The testator, of course, is the one ordinarily required to sign his will. At the end, and of course on the left margin of all of the pages of the will. In signing his will, the testator may use his usual signature. Okay? He can also use his initial. By initial, I refer to the shortened version of our signature. I think all of us have the so-called initial. Pag maraming pages yung dokumento, you don't usually use your full signature in authenticating the pages of the document. You simply use the shortcut, yung initial. Halimbawa, ang signature ko is something like this. Okay? Initial, ganyan. So, pwede ito. The initial, the shortened version of my signature. I can use that in signing my will. Okay? If the testator has a pen name, he happens to be a writer, and he has a pen name, he can use his pen name. Okay? Ang favorite na example ko dyan, yung si Nick Joaquin, a national artist. His pen name is Quijano de Manila. Okay? If he happens to be a movie star, meron siyang stage name or screen name, he can use his screen name. Halimbawa si Dolphy, pwede, Dolphy. Yun ang ipirma niya doon. Okay, instead of using his legal name, Rodolfo Quezon. Okay? So, that's permitted. All right. Can the testator use a nickname? Halimbawa, the testator has only 9 fingers. Kasi one time napaaway siya, sinalag niya yung bolo ng kalaban niya, naputulag isang daliri. Okay? Meron akong kababayan na ganyan napaaway, sinalag ba naman yung yung bolo ng kalaban niya. So, putol. So, from the time on, he became known as si Putol. Okay. Can that person sign his will with that nickname? Putol. Pwede. Okay? In other words, in the law on wills, signature is taken from the root word signum, mark, or sign. Okay? Now, can the testator sign his will with his thumb mark? Of course, alam natin, pwede yan. Okay? Kung gusto niyang medyo maiba, masyado marami nang gumagamit ng thumb mark, yung the mark of his big toe. Yung big toe ang ginamit niya, yun ang pwede rin yan. Okay? Why not? Okay? Because meaning na signature is mark. Okay? Extreme example, supposing he is a very romantic fellow, masyado makulay ang buhay, and he uses his lips. Okay? Medyo kinuskus niya sa stampad, tapos he made the imprint of his lips on the will with the intent to sign his will with the imprint of his lips. Would that be a valid will? Yes. As long as it can be established that that was really, he intended to use that as his sign or mark. Okay? Yun lang naman kailangan dyan. Alright. So, basically, he can use any sign or mark to validate his last will and testament. Okay. Next point. course, the law requires that a notarial will should have at least three or more credible witnesses. The law uses that adjective, credible. Is it necessary, therefore, during the probate of the will, that there must first be preliminary proof that the witnesses are credible individuals, in the sense that they enjoy a high degree of respectability, reputation for probity and honesty in the community? The answer is no. The Supreme Court has already held. When the law says credible witnesses, the law simply means qualified or competent witnesses. So there is no need for a preliminary proof as to the reputation of the witnesses for probity, integrity, and honesty. Okay. Can there be more than 3 witnesses? Of course, yes. Walang problema. Kung masyadong marami mong kaibigan na gusto magtestigo, pwede yan. Okay? You can have even 10 witnesses or more. But you should not have less than 3. If a notarial will has only 3 witnesses, that is not a valid will. Okay. Kung dalawa lang ang witnesses, the will is not valid. Okay. Paragraph 2 of Article 805 says, the testator or the person requested by him to write his name shall also sign, as aforesaid, each and every page thereof, except the last, on the left margin, and all the pages shall be numbered correlatively in letters placed on the upper part of its page. Okay. So, the testator and the witnesses are required under Article 805, Paragraph 2, to sign each and every page of the will except the last, on the left margin. Okay. Supposing they wanted to be different, they signed on the right margin. They would rather be called rightists rather than leftists. So sa kanang margin sila pumirma. Pwede ba? Pwede yon. They signed at the bottom margin or at the top margin. Pwede yon. As long as each page has the marginal signature of the testator and the 3 witnesses. Okay. Supposing that it is a 5-page will. Okay. It's perfectly executed, except that on page 3, you don't find the signature of the testator on any of the margins, or you don't find the signature of one of the 3 witnesses on any of the margins of page 3. Should the will be allowed? Okay. In this connection, you have the case of Icasiano versus Icasiano. I suppose you still remember that case. Okay? That is the case where the oppositor practically threw everything against the petitioner, everything including the kitchen sink, to use a trite expression. Okay. There was a will there. I think it had 5 pages. On page 3, there was a missing signature. Page 3 of the original of the will. There was a missing signature. One of the 3 witnesses did not sign on page 3 of the original of that 5-page will. What is quite amusing about the case is that, I always tell my students, when you are already lawyers and you are asked to assist in the execution of a will, always get these 3 individuals as much as possible, get these 3 types of individuals as witnesses. Sabi ko, number 1, kumuha ka one of the witnesses, yung pare o madre o pastor ng testator. Okay. Reason, whether you like it or not, these people have a very high degree of credibility. Okay? Rare is the judge who will not believe the assertions made by these people under oath. Okay? Pag pare o madre o pastor ang tumistigo dyan, under oath, sinabi, ganito nangyari, sigurado yung judge maniniwala. So, try to get as one of the witnesses. Yan. Number 2 kako, always try to get as another witness, the attending physician of the testator. So that if there is some question about the physical condition or mental state of the testator, the attending physician will be able to handle the questions along that line. And 3rd, sabi ko, always try to get as your 3rd witness a lawyer. Bakit naman? If there is a question about due execution, siyempre, if your 3rd witness is a lawyer, chances are, kahit na balik-balik ta rin yan on cross-examination, even by, he can handle the questions coming even from a very astute cross-examiner. In Icasiano, kaya nagkagulo-gulo. It was because of the failure of one of the witnesses who was a lawyer to sign on page 3. Ang pinagsimulan ng gulo yung abogado. All right. Anyway, so, the oppositor in that case opposed the probate of the will. I mean, that's not a valid, that's a forgery. Okay? So, that is a forgery. The signature there of the testate was forged. There was undue influence. Sabi. There was fraud. Okay? And of course, there was failure to comply with the formalities because one of the 3 witnesses did not sign on the margin of page 3. So that was the thrust of the opposition. When the case reached the Supreme Court, ano sabi ng Supreme Court? Before that, because of that opposition, ang ginawa ng petitioner, the petitioner presented to the court the duplicate original. There was a duplicate original. Also, and the duplicate original was perfect. It was signed by the testator and the witnesses on all the places where they are supposed to sign. So, perfect yung duplicate original. Sabi ng petitioner, if the original cannot be probated because of the absence of marginal signature of one of the witnesses on page 3, then let's just probate the duplicate original. Okay. The case reached the Supreme Court. Sabi ng Supreme Court, in Icasiano versus Icasiano, we have examined the testimony because both parties presented witnesses and we are not convinced that that will is a forgery. Okay? So we are not inclined to believe the assertions made by the oppositor that the signature there is falsified or forged. Okay. Sabi ng Supreme Court, the mere fact that the oppositors alleged both fraud and undue influence in one and the same opposition simply shows how weak their position is. Why? Because fraud and undue influence are mutually exclusive.